Welcome to our second lecture covering OSHA and workers' compensation law. In our first lecture, we discussed most of the topics that we'll be covering about OSHA, or the Occupational Safety and Health Act. We did a general overview of the law. We discussed some specific standards, or at least how those standards exist out there in OSHA world. And then we discussed the general duty standard and a couple of others in more granularity. Next, we talked about employer defenses to OSHA complaints, and we discussed the topic of prevention and OSHA enforcement. Next, we're going to be talking, or today we're going to be talking about the scope and application and record-keeping requirements, and then we're going to turn to the topic of workers' compensation law. And so let's get started. So I'm going to fast forward to slide 48, which is where we left off last time we were together. And here we go. We're going to talk about scope and application and record-keeping requirements. So this is an area that the federal government has preempted state action in this area. We do see a fair amount of activity in California with an organization called Cal-OSHA, which is the California Occupational and Safety Administration, but is commonly referred to as Cal-OSHA. It tends to be a bit more aggressive in terms of compliance efforts, and sometimes it's a bit ahead of the level of activity that the federal government has done in a particular area. I'm thinking about a repetitive stress injury specifically. But those entities have to, or the state bases, state entities are only able to act if the federal government gives it permission to put differing or more stringent standards in effect. Congress basically made a compromise and said, listen, we want to have one system of protection for all American workers. We don't want people in one state to be less protected than people in another state. So this is different than what we saw in discrimination law, wherein you can have one state where, for example, sexual orientation or marital status is protected, and another state where only the age, race, gender, religion, national origin type categories are covered by the statute. So there is less variation with respect to workplace safety, and I think in a way that makes sense because obviously all states and all workers want to be safe, and so there probably should be one, or perhaps should be one standard in this area. Okay, so let's go to OSHA. In addition to investigating rules and litigating rules, also makes the rules, as we talked about before. So it is an agency, and we see this in lots of agencies, that has all three functions of government action. You know, in the United States, we call it a system of checks and balances, where we have a legislative function done by Congress, the federal level by Congress, and then we have an executive function that's headed by the president, and then we have a judicial function, and that is, our court system. And each one of those branches has a distinct role that's different than the other branch, and they all have the ability to kind of check the power of the other branch. You may recall from history that one of the concerns the Founding Fathers had was one branch of government becoming too powerful or becoming despotic in terms of how it created activities and controlled the country. And so the idea was, well, Congress can't get too powerful because the president can step in. The president can't get too powerful because Congress can step in. And also the court has a role in this process too. So when we see within a governmental agency like OSHA that all three functions are within that agency, you might get concerned. You might say, well, gosh, OSHA is in some sense part of the executive branch, and now it has all three functions in that. Doesn't that undermine the checks and balances that we've talked about elsewhere? Well, no, it doesn't really, because even though there is a judicial action and there's a rulemaking action and there's an investigative or an executive action, all of these are ultimately going to be enforceable or not enforceable based upon actions that the Congress and the President and the judicial branch does. For example, let's say that OSHA comes up with an unconstitutional rule or some rule that is violative of a certain statute. And then it decides to issue a complaint against an employer based upon this unlawful regulation. And the employer contests this citation, but within the judicial function, the administrative law judge who works for OSHA finds in favor of OSHA. Well, the employer can still go to the federal court system. And so at that moment, then the federal court system, the courts can jump in and say, oh, OSHA, that rule that you developed is unconstitutional or unlawful in some other sense. The legislative branch can become aware of the unlawful actions of OSHA and change the law so that OSHA doesn't have the authority to legislate in this particular area, or there are certain limitations as to the degree of legislation that it can do. An example of this is in the employment law area, but an example of this is the Food and Drug Administration has been prohibited by Congress from regulating cigarettes to a fair degree. And you can see how certainly cigarettes are inherently dangerous, and there certainly is a chemical action that the nicotine has on people that does act like a drug. And so you could say, well, that would make a lot of sense for the Food and Drug Administration to regulate tobacco. But probably if it did regulate tobacco, it would conclude that tobacco isn't a safe product and shouldn't be available to anybody because, after all, it causes cancer and other problems. And so Congress had said, well, as a public policy matter, we have decided that we want to have tobacco available to adults. And so therefore, we don't want the FDA, the Food and Drug Administration, to legislate in that area. So once the Congress makes that decision, then the FDA can't look into that area anymore. It's going to need to use its resources in other disciplines. So that would be an example about how Congress can interact with an agency and affect kind of the scope of its mandate, so to speak. And then, of course, the executive branch, headed by the president, has the ability to tell these various agencies how to go about doing their tasks. The president is responsible for appointing, and Congress is usually responsible for confirming the appointment of the head of the agency. And so that person gets his or her marching orders from the president, in some sense from the Congress. And so if the president, who's the head of the executive branch, feels like there ought to be more attention on this issue or less attention on this issue, then he or she can direct that action. So even though the OSHA has all three of the functions, there still are those checks and balances present. Okay, so we've talked now about scope and application. Now we're going to talk about the record-keeping requirements. This is one area where HR does need to be involved to make sure that the books are being maintained appropriately, the records, the logs. Log 300 and Log 100 are two of the big logs that we deal with in an OSHA situation. Not all employers are required to keep these logs. It's important to know whether you happen to be one that needs to keep it or whether you don't have to keep it. But if you happen to be one that needs to keep it, you need to keep it on a calendar year basis. So new log every January 1. You need to retain it for 5 years, and it needs to be available for inspection if OSHA shows up. So you can't be backlogged. You can't say, oh, we haven't maintained it. We'll get to that someday. No, it needs to be maintained every single day. If you don't dot the I's and cross the T's, there can be very significant fines. You definitely want to see that as a priority. Many times the loss prevention or the security function within an organization is the one who keeps these logs, but certainly HR needs to be kept in the loop and aware and make sure that there are processes in effect that will result in this being maintained in an appropriate manner. Let's talk about the particular things that need to go on this log, at least to some extent. Employers are required to record all work-related injuries or illnesses, all the days that are away from work due to injury or illness or whatever, and not so much illness if it's unrelated to workforce issues. Loss of consciousness, for example, if somebody gets knocked out at work. For example, a fatality at work must be reported within 8 hours. Inpatient hospitalization, amputation, or eye loss must be reported within 24 hours. So these are particular dates, and you can see why it's important to let OSHA know, because OSHA is very likely in a fatality situation to want to be out there ASAP to make sure that other individuals who work there aren't in jeopardy as well. And so that's why there needs to be this very quick turnaround time. So what are the types of recordable occupational injuries on these logs? Things like death, obviously, if the person needs to take time off from work because of the injury. If they need to have some kind of work restriction because of the nature of the injury, they need to move to another job. Medical treatment beyond, basic first aid, a Band-Aid or an ice pack, that's not necessarily going to require that there need to be recorded, but if it's something beyond that, maybe stitches or something like that, then definitely there needs to be the recording. Loss of consciousness would be another. And then, again, this is kind of an umbrella term, significant injury or illness diagnosed by a doctor. So those are situations where you do need to make sure it's recorded. The right hand needs to know what the left hand is doing here. Sometimes there can be breakdowns in communications in very large facilities, and so you make sure that process is in effect. One of the things that also complicates this are all the privacy rules that exist out there under the Americans with Disabilities Act and HIPAA and other laws that shouldn't interfere with the recording of OSHA log information. I'm not going to talk about mine safety, but obviously if you work for a mine, there's very, very specific rules about how these mines must be maintained in a way that is going to maximize the safety of the workers. Mine work is obviously inherently risky. There's risks that we just can't solve, but the goal, of course, of this legislation is to make it as safe as we can make it. Okay, so we are done with OSHA. We are now going to move on to workers' compensation law. You can see the natural the natural connection between workers' compensation law and OSHA. OSHA has to do with keeping a safe workplace, and workers' comp is about compensating workers who were injured in that hopefully safe work environment. There's no such thing as a workplace that is completely free of any risks. Accidents will happen in the safest facilities that are around, and so you have to be prepared. Yeah, you obviously want to manage them and make the risks as small as they can be, but when they do happen, you want to make sure that you are addressing those appropriately. So now we're going to talk about when OSHA didn't quite work for us, didn't protect us from all the dangers, and now we have workers' compensation issues. Let's get started. By the way, you may, if you're an older person, may have grown up hearing workers' compensation being referred to as workmen's compensation. That's the old-fashioned term for it. It's no longer in most state statutes. It's not in the Texas state statute. It reflects the fact that once upon a time, most workers, especially workers in the types of positions that are likely to experience an injury, were male, and so the term was workman's comp. But obviously women are in the workforce, and they sometimes also occupy jobs that maybe were historically held by men. So workmen's compensation, you'll still hear occasionally, but it is probably not the best term to use. It's not accurately describing the law, and it certainly isn't as enlightened as we might like to be. So let's consider what state workers' compensations require. They require that employers provide medical care and replace at least partially the income that people who are injured at work experience. This is oftentimes done through an insurance product, although there are the options for large employers to be self-insured in this area. That is the usual pattern that we see in workers' compensation laws. Now, exactly how this happens varies from state to state. In some states, the employer is simply required to purchase usually a commercial insurance product. Liberty Mutual, AIG, those are two market leaders in this area. In other states, the employer is required to purchase an insurance product that the state actually maintains and regulates. And so there is literally just one-stop shopping as a monopoly on that market for that particular state. In Texas, for employers who choose to use workers' compensation coverage, the employer can use a variety of different private insurance products. So you have to kind of know the state that you're in, what the specifics are with respect to how the laws work and how the process is in terms of enforcement. We'll talk about the particulars of Texas law in a few minutes. They really are very, very different than what we see in most states. Okay, so most states provide, and when I say most states, I mean like 49 out of 50. So the vast majority of states, in other words, provide employees with an exclusive remedy. So there's only one place the employee can go, and that's the workers' compensation statute, to be compensated for workplace injuries or occupational diseases. As I said, Texas is really the sole exception, although Oklahoma's statute is somewhere in between, kind of. We use an expression in Texas saying that employers go bare, meaning that they kind of are doffing or taking off the protection of the workers' compensation insurance. And we describe these employers who go bare as non-subscribers. This is a relatively new thing in Texas. I mean, not super new, but it was something that came up in the 1990s, early 1990s. And so it's been around in Texas for quite a while, but it hasn't really caught on in other states. It's very, very popular in Texas amongst employers, though. I would say that more employers than not have chosen to be non-subscribers. As a result, as you can imagine, Texas workers' compensation law is very different from the law in the other states. And so our textbook really doesn't talk about workers' compensation laws as we have it in Texas. Still, that information is useful for two reasons. For one thing, you may well be supporting employers who have operations in other states. And certainly in those other states, even an employer has chosen to go bare in Texas, well, that employer is still going to have to provide workers' compensation insurance protection to its workers in the other states. So you still do need to know about this. Secondly, your employer, even if your employer is Texas-based, may still choose to subscribe to the workers' compensation scheme that we have in Texas. And so you need to be aware of it simply for that purpose. Many choose not to, but certainly many still do choose to subscribe to that particular program. Here, let's first of all kind of go through some aspects of workers' compensation coverage, whether you are in a state that requires it or in a state that doesn't require it, like Texas. First of all, this is not a general health insurance product. This is not intended to cover the needs that an employee has for health insurance. Accidents that the employee has off the clock that aren't related to work are not going to be covered by workers' compensation. It is, in fact, the responsibility of the employee to show that the injury that he or she experienced arose out of his or her employment. This sometimes can be a source of dispute and debate. And so it is something that sometimes is very obvious, but sometimes isn't obvious. So an employer is concerned about keeping a safe work environment for all the reasons that we've talked about before. Being a good corporate citizen, being concerned about one's employees, being concerned about productivity in the workplace, morale issues, maintaining the best workers, being concerned about the possibility of OSHA citations. All of those are good reasons why an employer wants to maintain a safe and working environment. And hopefully those would be enough in and of themselves, but if those aren't, the employer has the issue of workers' compensation. You may say, well, if I have to buy insurance for it, I mean, what do I care how many claims are filed against my insurance or not? Well, it's very similar to when you have a car accident. You buy insurance, so if you have a car accident, you're covered. But you don't really want to file a claim, right? Because you know if you file a claim, your insurance is going to go up, or very likely it'll go up. Sometimes that happens even if it's completely not your fault, right? And so we call that an experience rating in the insurance business, meaning that now the insurer has some information about the nature of your workforce and the risks associated with your workforce. And so the rating can go up or it can go down. And that makes sense. You know, if you happen to have, well, let's say you're in the construction industry and you specialize in high-rise buildings, which probably, I'm guessing, probably provide a lot of opportunities for some pretty significant injuries. That type of business, even if it's super, super safe and very, very careful and is a good corporate citizen, is probably going to have a higher experience rating than, say, a white-collar office environment, because there's just not that many things that can go wrong in that white-collar office environment. So it makes sense for the construction employer to pay more for its workers' compensation coverage, because it's going to end up paying out more, or the insurance company is going to pay out more claims. That's just kind of a common sense. If I'm a type of driver who am always on a 75 or a busy freeway, I'm more likely to have an accident even when it's not my fault. And so it makes sense that my experience rating be higher than if I'm the type of driver who rarely drives, and when she does drive, she's driving in, you know, roads with 30 or 35 mile an hour zones. We also see experience rating in the unemployment tax situation. We're not going to really talk about unemployment at this point, but it's the same idea. If it ends up that from my place of employment, relatively few unemployment claims are filed, then that's going to mean that I pay a lower rate than one which has a lot of unemployment claims being filed. That's one thing that HR managers often are very involved in managing. So, obviously there are times where people will need to file for unemployment benefits. There's been a layoff or some other situation, and you certainly should not discourage individuals from doing so. But if you can manage the workforce appropriately, you may find that you're going to have a lower experience rating in that area, and that's going to save money for your firm. So that's a smart idea. But again, we're not talking about unemployment at this time, but the same idea holds. And one of the things to think about when you're looking at this is that an experience rating either for workers' comp or for unemployment is something that can be managed. I mean, again, if you're in a very high-risk industry, you're not going to have as low as other people, but you can have a relatively low one for your industry by having good practices in effect. So maybe this is the range for your particular industry. You want to be maybe down in this area if you can manage it with a lower rate than others might have. So that's what you're thinking about as an HR professional. How can you manage this so it's going to be as low as is reasonable, and given the industry that you're in? Well, let's talk about coverage. Okay, so workers' compensation is provided, and the idea is that it's going to be a no-fault basis. The employee is giving up his or her right to sue the employer based upon the incident. It may be that the employer's equipment was unsafe, or the employer gave an instruction to the employee that was unsafe. It may really and truly be the employer's fault. But the employee is in a system where there's workers' compensation present, the employee is giving up that right. I mean, the employee may not be even aware of giving up that right, but he or she has. He or she cannot sue the employer except under the workers' compensation system. So that's something that the employee is giving up, but the employer is giving up something as well. And we'll talk more about this later on, but the idea is that the employer gives up some of the defenses that he or she or the employer might have, such as contributory negligence, the fellow servant rule, and the assumption of risk. We'll talk more about this in later slides, but keep in mind that both the employee and the employer are giving up something, and they're getting something as a result of this. The system replaces a system that was already in effect, and therefore there's advantages and disadvantages. So as a result, the employee's exclusive remedy is against his or her employer, but not against others. Consider for a second this category of litigation. Let's say I happen to be a worker. Maybe I worked in construction, and as a result of my work in construction, or maybe some other industry, I was exposed on a pretty regular basis to asbestos. I mean, it's not really a major issue these days, but once upon a time, asbestos was very, very commonly used. And asbestos, as you know, has little fibers in it, and those can get released in the air and get embedded in the lungs, and they can cause a disease called asbestosis that can lead to a death, and certainly great a physical injury and great compromised health. And so it's a major, major issue. One of the reasons why we don't see asbestos anymore, because of these features. So let's say I worked in this environment for many years, and I become ill as a result of this exposure. Well, I'm going to be restricted to the workers' compensation statute vis-a-vis my employer. Even if my employer perhaps did not give me all the safety tools that ideally I should have had, didn't give me as much training as I would have benefited from, I'm still probably going to be restricted against my employer to the remedies available under the workers' compensation statute. But that doesn't mean I can't sue my non-employers. For example, the companies that produce the asbestos, or the companies who produce the various tools and other things that used asbestos. So I might well be able to pursue litigation against those entities. And in those situations, there isn't going to be a workers' compensation statute that limits my recovery. So just flagging that, it's not really an HR issue, but it is something that does come up from time to time. So let's say I'm at work. I am taking my 15-minute break. I'm running to the bathroom. I slip on a big puddle of water. I'm in my employer's facility. The employer has the ability to control to make sure there aren't puddles of water. Or maybe there's a coffee area in my place of employment. Maybe we don't even have set breaks because people just get up and get a cup of coffee when they want to. And when I am there, I pick up the coffee mug and I get shocked, or maybe I get burned because the coffee's too hot, or I spill coffee on myself and I get a burn that way. Those injuries are probably going to be compensable in most circumstances if I am at work doing my work stuff while all these events are happening. But let's say that the reason that I slipped on my way to the bathroom was because I had just taken or just drank some alcohol or maybe took some illegal drugs or something like that. And so perhaps that's the reason why I wasn't seeing that puddle. Well, usually those injuries are not going to be compensable under the workers' compensation statute. I'm not going to talk about this particular case. It's not that helpful. It's kind of an interesting one if you want to see how these cases do develop when we're looking at the issue of the connection between work and the injury itself. Injuries or illnesses arising out of employment. Let's consider the issue of illnesses. Generally speaking, illnesses are not going to be compensable. So let's say my neighbor in the next cubicle develops the flu, and lo and behold, I get the flu. I mean, there's a pretty darn good chance I got it because I happened to be working next door to Typhoid Mary next door. She came into my office several times. She'd be coughing and sneezing and carrying on, and her hand would have, would be touching my stuff and all kinds of things. And so there's probably a pretty good bet that I know exactly how I got the flu. It's because of her, and I was at work. So you might think, well, surely you can then claim workers' compensation benefits for the 3 or 4 days off or in the medical bills that I have resulting to that. Really, though, for illnesses, they are usually not considered compensable. There again, I'm guessing in the asbestosis area that there's an exception because those are the types of injuries that you only have if you happen to have gotten them in an industrial situation. But flu, you can get anywhere. And it's possible I got it from my neighbor, but it's also possible when I was doing my grocery shopping. I got it from the person who was in front of me in line at the checkout, or perhaps I got it, from my husband or my wife or something along those lines. And so generally speaking, your garden variety illnesses are not going to be considered compensable under the workers' compensation statute, unless it's something like asbestosis that you're only really going to get because of that type level of exposure. And so generally speaking, you're going to be out of luck with those types of illnesses. Now, that doesn't mean that an employer shouldn't be concerned about, making sure that your employees have access to flu shots, TB tests, things like that. Certainly those are good practices, because even if workers' compensation isn't an issue, employee absenteeism is a huge drain upon the profitability and productivity of a workforce. And so you still do want to make sure that you're maintaining a safe workplace, despite the fact that workers' compensation probably isn't going to be in play. Let's discuss the defenses that an employer can have to workers' compensation. So we'll talk now about historically. So let's go back in a time machine to, we'll say to 1900. Actually, let's go back to 1880. At this time, there were lots of sweatshops in the United States and elsewhere. Working conditions were oftentimes very difficult in urban areas. Many times the workforce were recent immigrants who were unsophisticated, maybe didn't speak English, didn't feel like they had a lot of options. You might have heard of the Triangle Factories fire that happened in New York. Hundreds of workers, many of them recent immigrants from Eastern Europe, died because the factory that sewed the shirts was very dangerous. And as soon as that fire started, it was impossible in many cases for workers to escape. So very, very horrible situation in those cases. And that was and to some extent the reality of workers. And when jobs are scarce, people sometimes are willing to take jobs that are dangerous because they have to feed themselves and their families. Children are working, and certainly children, in addition to all the other reasons we don't want children working, one of them is that they don't have a good sense as to how to gauge risk associated with various activities. They don't have a sense of, oh, I shouldn't touch that hot wire because I'll become electrocuted, or I should be more careful in this area because there isn't a guardrail or something along those lines. They lack that life experience and the judgment that comes as their brains develop. So, so that was the environment, say, in the 1880s. And unfortunately, accidents were frequent. Let me advance and show you some of the things that we have here. So let's say that I am in one of these factories in the 1880s, and I get hired on Monday, and I receive some rudimentary training about how to work my machine, and I start working on it. And my next door, the person who's working in my next cubicle or the next workstation, as I'm talking to her, I notice that she's missing a couple fingers. I say, what happened? She goes, oh, well, one day I did not use the machine appropriately. I didn't pull up my hand fast enough. It's very tricky to coordinate all those things, and I just got distracted for a second, and guess what? I don't have two fingers on that hand anymore. Wow, that's pretty awful. And when I'm in the break room a few days later, as I'm having my lunch, I see somebody else who is also seems to have experienced some injury at work. They've got some burns on their hand. I said, what happened? And he says, well, sometimes the boiler overheats, and as a result, I was too close and I got burned, and it happens here sometimes. Oh, okay. Well, okay, I understand that that's something that's occurs here. Now, some employees might decide once they hear these stories that, oh, I'm out of here, not going to stick around. This place seems too dangerous. But I may decide to stick around simply because I need the paycheck, and I may decide, well, okay, it's bad here, but all the other places that I might obtain employment are also dangerous. So there's really no better place for me to go, so I might as well stick it out here. So the next day I come to work, and the nature of my job involves me from time to time carrying things with another employee, because there's too heavy for one person to carry on my own, on his or her own, and so I'm carrying it with my other employee. And he goes, you need to be careful here. I'm like, oh, okay, well, I'll be careful. He goes, yeah, last week somebody was carrying one of these items with another coworker. The other coworker sneezed in the middle of carrying it and kind of lost her grip on the item, and so she dropped it, and the item shattered, and both of them got cut up pretty badly. Whoa, okay, that's scary. So sometimes the coworker can be the cause of whatever the injury might be. Anyway, so I decide to continue under those circumstances. I've seen how the injuries can happen. I've talked to the people, and I know something about them. So let's say, unfortunately, 6 months later, I'm at work, and one of these categories of injuries actually does happen to me. Maybe I lose some fingers, maybe I lose my eyesight. Lots of things can happen, and my employer may even decide to dismiss me. You're not useful to us anymore. You are missing an arm, or you're blind, or something along those lines. We don't need somebody who can't use their arm or can't see under these circumstances, so we're firing you. Under those circumstances, I might go to an attorney and say, hey, this terrible thing happened to me through no fault of my own. I was badly injured at work, and I got fired on top of that. I want to sue that company. I want to sue that awful, awful company. Well, the attorney is likely to have said back in 1880, I'm very sorry to hear about your injuries, but you got a lousy case. And let me explain to you why you have a lousy case. There are 3 defenses that the employer is likely to be able to advance, or at least possibly able to advance, and these are end-of-game scenarios. If they're able to prove these defenses, you're not getting a plug nickel. So let's see them. One is contributory negligence. This is the idea that I contributed in some way to my injury. Think back to that first woman I talked to who's missing 2 fingers. Remember, she admitted she got distracted for a second. I mean, no one can focus like a laser beam for 8, 10, 12 hours a day, every day. You're going to get distracted. That's human nature. And what she said is, you know what? I had a moment of lack of focus. And as a result, I lost my fingers. Well, guess what? She was negligent during that period of time. And because she contributed to her own injury, the rule used to be that that barred her from suing anybody else for her injury. She has to be 0% responsible under the old contributory negligence doctrine before she can successfully sue somebody else for the injury. This rule is no longer in effect. We now have a rule called comparative negligence in Texas and in, I think, every other state. And how comparative negligence works varies some extent. But the general rule in Texas is that if I am 40% responsible and the other guy is 60% responsible, then I can sue him, and let's say my damages are 100,000. Well, I can, excuse me, negligence. Here we go, sorry, here. I can sue him for 60%, so I can sue him for $60,000. If I'm 50% responsible and the other guy, or maybe it's more than one entity, is 50% responsible, then I can sue him for 50% of my damages, in this case, $50,000. If I'm 51% responsible in Texas, I'm not able to successfully sue anyone. So the other person who may be 49% responsible isn't going to be sued. I mean, that's how comparative negligence works. But back in 1880, the rule was contributory negligence. And so my friend at work who's missing the fingers can't sue successfully her employer because of contributory negligence. The next one is assumption of the risk. Remember the guy in the boiler room who got burned badly because the boiler overheated? Well, he knew that that happened sometimes. Remember, he said sometimes this happens. Assuming he knew that before he actually got burned, he assumed the risk. He knew the defense is based upon the injured party voluntarily, and when we say voluntarily, it doesn't mean he had other good choices, but he chose to come to work that day. He voluntarily exposed himself to a known danger created by the other party's negligence, in this case the employer. Maybe there was a different design of boiler that would have been safe, but the employer didn't bother with it. Well, once the employee knew that there was a chance that it could overheat and could result in burns for people who are in that environment, he assumed the risk and he loses his right to sue. Again, the law as it existed in 1880. For the most part, comparative negligence has replaced assumption of risk in modern day tort law for the most part, though there are some remnants of assumption of risk. But keep in mind, comparative negligence didn't exist in 1880. And then the last one is the fellow servant rule. Remember the scenario where the employee sneezed and then dropped the item, causing it to shatter and causing both parties to get cut up? Well, in this situation, the fellow servant can get sued. So if I'm the one who's cut up because the other worker dropped the item, I can sue my fellow servant. But the law used to say, okay, you can sue the other guy, but you can't sue the employer because it's not the employer's fault that the other worker dropped the item. And when we use the word servant, again, you may remember this from one of our earlier presentations about master servant. The word servant here basically just means employee. It doesn't have any kind of meaning of like maid or butler or anything like that. It's an old-fashioned word meaning employee in this context. So fellow servant does not, under the old meaning, it would mean that I could sue that coworker but not the company. Now the reality is there's really no point in me suing the coworker if he or she is working in the sweatshop. He or she doesn't have any money, right? Otherwise they wouldn't be working there. So you can see how these really were essentially a bar to anyone in a sweatshop situation successfully suing the employer. So the workers' compensation statute was a way to resolve those issues. What it basically was saying is, look, we're going to make all of these defenses go away. The employer cannot advance these defenses. But we're not going to just make the employee get whatever the employee wants. We're still going to put caps on. There's kind of a trade-off here. We're going to get rid of the defenses so the employee can successfully get some compensation from the employer, but the employee is not going to be able to get punitive damages. The employee is not going to be able to get mental anguish E-type damages. The employee is not even going to be able to get a complete wage replacement. Very likely, depending upon how the statute is written in your particular state, the employee perhaps doesn't have the ability to go to his or her own doctor. They may be able to be directed to the doctor that's going to treat them under these cases. So there's lots of limitations, but and those benefit, frankly, the employer, but the employee is getting the advantage of no longer having all of these defenses, challenging his right to even successfully be a candidate for suing the employer. So this is our system now in states that have or all states have workers' compensation, but for those employers in Texas who choose to subscribe, we have the no-fault system. This is the legal environment for workers' compensation laws, which mean that workers injured on the job are entitled to recover from their injuries without having to prove who was at fault. Doesn't matter whether it's a fellow servant. Doesn't matter whether the employee himself contributed in some way to the injury. Doesn't matter whether the employee assumed some risk when she came to work that day. So this is the schema that we have. And so what we have, so you can see how these employers' defenses once made it difficult for employees to recover. Well, in a few minutes, though, we'll talk about what Texas's system is like, and we'll go back to that slide right there. So whether or not your employer chooses to be a subscriber to workers' compensation in Texas or chooses not to be, these are some best practices to keep in mind when you develop your HR policies and procedures. Employers should require that all employees report all workplace injuries as soon as possible. We do this perhaps for OSHA log purposes, but also for just general safety. Somebody bleeding on the equipment is not a good idea. And so things like bandages and antiseptics and cleaning stations and things like that should be available to employees. It's important in terms of keeping the workplace safe, but also it's an important morale issue for employees. Employers should err on the side of caution in referring injured employees for medical treatment. You ought to be inclined to send them for treatment versus not send them for treatment. You know, somebody gets a hit on the head, oh, I feel okay, I'm just a little bit dizzy. Then they go home and they pass out while they're driving home because they have a concussion. Not so good, right? We don't want to have that type of situation because it creates obviously very bad outcome for that employee, but maybe that employee hit some other person's car. And under those circumstances, there wouldn't be a workers' compensation statute that would insulate the employer from the protection from that third party. So you definitely want to err on the side of seeking treatment for employees who potentially might need treatment. Report injuries as soon as possible and report them thoroughly. Again, if it's an OSHA log situation, that makes sense. If it's a workers' compensation matter, you want to report that to the workers' compensation carrier. You want to, if there is an injury, you want to examine, well, how did it happen? Why did it happen? And perhaps how can we go about making that less likely to happen in the future? Is there some safety change that we can make? And these hazards should be abated as soon as possible, and when it's not easy to abate them quickly, refer them to your safety committee so that they can address these issues more carefully. Finally, and this is important, an employer should not contest workers' compensation claims unless there's a reasonable basis. The default status of an employer ought to be that we're concerned about you, we're worried that you're injured, we want you to be taken care of. Yes, there are fraudulent claims. There are exaggerated claims of workers' compensation. They get filed from time to time, in some places more commonly than others. And I'm not encouraging you to not be diligent and not to consider that possibility, but also to recognize that genuinely people are injured in the workplace, and having an adversarial relationship with every worker who's injured is not a best practice by any means. It's not good for your workforce, it's not good for morale, and it's ultimately not good for your bottom line. Okay, so let's talk about workers' compensation benefits. What does the worker get? Okay, so generally medical expenses are going to be entirely compensable. But again, there may be some limitations on where the worker can go for those types of benefits. For example, there may be only certain medical clinics where benefits can be provided. The insurance company may not automatically approve every type of procedure. For example, there might be more than one way of treating that particular condition. Maybe, for example, there may be a less invasive, maybe surgery is one option, maybe physical therapy might be a different option. Well, the negotiation between which one you're going to take or which one you're not going to take under workers' compensation statute is definitely a thing that happens. Lost wages are going to have statutory caps. There's not going to be 100% reward of lost wages, and even in situations where there's going to be some lost wages, there may be limitations to some extent based upon the diagnosis and other factors. Again, this varies from state to state. Let's look at some benefits that state law typically do provide. So again, they'll provide temporary disability benefits, which is going to be that percentage of the employee's lost wages. And then there'll be permanent disability benefits. So let's say that a person, again, loses a finger because of a workplace injury. Well, of course, there'll be some period of time where the person is recovering from the injury. Maybe they've needed surgery or stitches or some other treatment. But at some point, they're considered back to the new normal, whatever that is. And so then they will oftentimes get what's called a permanent partial rating. So they will receive some kind of percentage rating, and much of this is statutory. So, losing a pinky finger from your non-dominant hand, what is your rating? Maybe I'm making numbers up here, but let's say it's a 3% rating. Well, that would translate into a certain lump sum payment for you. And this is after you've returned to full health. Some of those are very statutory, and so, yep, you lose this finger, you lose this degree of sight, you lose this particular thing, and you get the schedule. But lots of times the rating that you're going to get, the permanent partial rating, is going to be litigated. For example, let's say you suffer from chronic back pain. Well, that's a difficult thing to quantify. Obviously, severe back pain can really be very, very disabling, but maybe it's not so severe. Maybe you're exaggerating. Maybe you're not exaggerating. You can see all the different issues that spring from that. And so oftentimes these do result in litigation. So again, those would be examples of unscheduled disabilities. So that you have to have a hearing to figure out exactly what the level of injury is in terms of a permanent partial rating. Now, like with OSHA, HR professionals are oftentimes not as involved in workers' compensation administration as, say, the loss prevention function or the entity within a corporation that is responsible for insurance products. Although the HR department oftentimes is the entity that takes the claim and forwards it to the workers' compensation carrier. So there's usually some role here. If you are a paralegal with a law firm or with a legal department that does HR work, you're also probably not too involved in workers' compensation issues because attorneys specialize in this area. Usually an attorney who's a workers' compensation attorney just does workers' compensation. It's very much of a specialty area. One of the natures of the business is because there's not a lot of money in individual cases is that the practice involves having lots of cases that no one of which do you spend a ton of time on. And so it's a volume business, so to speak. So as a result, you really need kind of efficiencies of scale so that you kind of have these process that you go through doing, this is what we do here, this is what we do here, this is what we do here. It doesn't make sense to kind of dabble in that particular industry. So like OSHA, workers' compensation is something that you either kind of specialize in and do it full time, or you know a little bit about, but you're not the one that's in the front lines. And so some of the stuff I'm telling you is kind of good to know stuff. You need to know a little bit about the vocabulary, but you probably won't be the ones doing the deep dive unless, of course, you decide to move over into that industry. Okay, I'm not going to talk about this case, not something that you need to know about. So now we're going to talk about Texas's law in this area. This is, again, this is a topic that you won't really find in the textbook because Texas is kind of alone in this area. We're special, as we like to think of ourselves. So you won't find this information in the textbook. So please be sure to look this over carefully before you go to take any tests. So the big difference is workers' compensation coverage in Texas is optional, and it's optional at the decision of the employer. So I, the employee, don't decide whether my employer subscribes or not. The employer subscribes or doesn't, and whatever decision the employer makes is going to affect all of the employees in that facility. The idea here is that I can, if I'm the employee, decide which place I'm going to work for based upon whether it's a subscriber or not. I mean, that information has to be available to me, but I don't think that's a very common basis for an employee to decide, I'm going to work for company A because they're a subscriber, but not for company B because they're not. I'm not going to say it's never happened, but that's a pretty unusual thing to focus on in the interview process. So generally speaking, the employee is just going to be presented with that information one way or the other. And my guess is a lot of employees aren't even aware of whether their particular employer is a subscriber or not a subscriber. If the employer chooses to be in the workers' compensation system, this will make that employer like employers in all the other states. The employer cannot be sued through the court system, so all those defenses that we talked about before, comparative negligence, again replacing contributory negligence and assumption of risk, the fellow servant rule, those make it really difficult in the litigation standpoint for the employer to be sued. Plus, the workers' compensation statute typically says employers can't be sued, except in a very few kind of carved out situations. And then, of course, the workers' compensation benefits that are available to the worker are the sole source of compensation for the worker, for an injured employee after a workplace injury. Again, the worker can sue that non-employer, the manufacturer of whatever caused the injury, for example, or if the employer is in an office building, for example, maybe and the employee is injured because of the way the facility was maintained, then the employee files a workers' compensation claim with the employer, if the employer is a covered entity, and then could file a lawsuit against the landlord. So again, the employee isn't limited completely, but just with respect to the employer. So let's talk about the other option that we have in Texas. Employers not providing workers' compensation insurance are referred to as non-subscribers, or they're described as going bare, meaning they don't subscribe to workers' compensation insurance. Obviously, non-subscribers save money because they're not paying the premiums of workers' compensation insurance, but they also lose the protections because, as we said before, workers' compensation is a trade-off. The employees get something, the employers get something. Well, if you opt out, you save the premiums, but you also lose out on the benefits that employers got under those situations. So, for example, non-subscribers lose important legal protections such as immunity. Of course, in this context, we mean immunity means you can't be sued. So, immunity from most lawsuits filed by injured employees. Non-subscribers can also be forced to pay high damages if an injured employee can prove to the court that the employer was negligent in any way, possibly even punitive damages under that context. The workers' compensation advantage for Texas employees when they agree or subscribe to be bound by a no-fault system is that the injured workers are limited to the financial recovery to which they can obtain under workers' compensation laws. Whether or not your employer is a subscriber or not, the employer has to report injuries to the workers according to the Workers' Compensation Act, and I'll show you that information in a couple of minutes. Okay, yeah, let me go back here then to this particular take on it. So let's say that you're, let me go ahead and I'm just gonna do it for a second here, discard, and we'll go back. So we have a clean version here. So let's assume that our particular employer has chosen to go bare or to be a non-subscriber. So now the employer, again, the standard now is contributory negligence, comparative negligence, not contributory negligence. So now the employer is going to need to be sued by the employee if the employee wants to collect based upon the injuries that the employee had in the workplace. So now the employer has the ability to say, well, I mean, Bob was goofing off. Bob shouldn't have been sticking his hand there. That's not what you're supposed to do with that machinery. It's his own fault that his hand was broken. He's messed up. He contributed to his own injury. He has comparative negligence. And if the employer can prove that the employee was over 50% responsible, even if the employer bore some degree of responsibility, maybe not having the right signing up or the right training for Bob, but if it was less than 50%, guess what? The employer doesn't have to pay at all. Assumption of risk is for the most part subsumed under the comparative negligence standard. I'm not quite sure what the status of the fellow servant rule is. My guess is that that's really no longer functioning because of the idea of the agency principle here. But comparative negligence is a pretty strong tool that the employer has because in many cases, certainly not all, but in many cases, the employee in some sense contributed to his or her own injury. So obviously we're not looking at a no-fault situation here. So in some sense, the employer is taking a bit of a gamble. He is saving some money in premiums, but he's taking a risk that he will get a big judgment if something bad happens. I'll draw a comparison here. When I first started to work at JCPenney, in fact, I was 28 years old. And in my previous place of employment, we were just given a single insurance product and we didn't have to make any choices. When I came to work for JCPenney, there were two different products, two different insurance products that we could buy. Obviously, the company paid a significant amount of the premium, but we had two different insurance products that we could pick. One was a pretty high monthly premiums, but pretty robust coverage. Lots of things were covered. And then the other was a low premium, but lots of things were not covered. The routine stuff, the head colds, the everyday illnesses, you were going to have to pay for them out of pocket. Now this second product did cover the catastrophic illnesses, but you almost had to spend, I think, $5,000 or $6,000 or $7,000 before you even got into having coverage under those circumstances. And the idea is that this would be a good product for people who are very healthy and who had a significant nest egg. They had some savings so they could afford to pay these bills if they needed to pay these bills. So I asked the person who was meeting with me, he was a gentleman by the name of Tom. Tom was about 40 years old at this time. And I said to Tom, what do you recommend? He goes, well, I mean, every person's situation is different, but I happen to choose the second option, the one with a very high deductible. And a lot of our younger people, especially those that have a significant amount of money saved, should consider that. That can be a good choice. And so I made my choice, and about 6 months later, I learned that, and one of the things that Tom had said was Tom was a marathon runner, very, very active, very fit, very health conscious. About 6 months later, he was diagnosed with terminal brain cancer, and he passed away within a year after that. Obviously, he did not know what the future would hold for him. And because he was a subscriber to the cheaper one with higher deductibles, he ended up, paying more for his insurance. Obviously, once he got past his deductible, then he was enjoying robust insurance, but it did cost him $5,000 or $6,000 or $7,000 to get to that level. I mean, at the end of the day, it was not the most important thing in his life since he recognized he was going to be passing away. But you sometimes don't know what the future holds, and so sometimes you take the risk, you choose to buy or opt for the more dangerous product, and you end up paying for it. Sometimes you luck out and you buy the high risk and you're okay. And in fact, I followed Tom's advice and actually bought the premium policy, or low premium policy with the high deductibles. I used that for several years, I think until I got married and had children, and never really had claims and saved quite a bit of money. So again, the takeaway here is that every situation is different, the stomach that the employer has for risk, the nature of the industry, things like that should play a role in that decision. So let's flip here for a second to information that the state of Texas provides us about these options. I have put a link on our course in the module to talk about this, but here's kind of an overview. So this is the link that I've given you. This is what the page should pop up to. So it gives you information about employers who choose not to have workers' compensation coverage. Again, we call these non-subscribers. For one thing they have to do is they have to let the state know they don't have coverage, and they still have to report injuries and illnesses to the entity. And then here's more information about employers who choose to have workers' compensation coverage. And for very large employers, they can actually have certified self-insurance. And then here's some information about what the employer needs to do, the rights and responsibilities. Here's the injured workers' rights and responsibilities. Here's some acts and some rules. But I'm going to flip down here also to another resource, which is employers' FAQs. And I find this helpful. I'm going to scroll down here. As an employer in Texas, do I have to buy workers' compensation coverage? And the answer is no, it's not required in Texas. But there's a description here of the benefits and the potential factors that you might want to use in your analysis. So if you have an interest in this topic to become a little bit more granular, I encourage you to spend some time on this link. I don't expect you to have a deep sophistication or knowledge about this, but I do want you to have at least the level of knowledge that we've discussed in this presentation. I'm going to fast forward to where we were before. And I think we covered this one, yeah. So now we've covered all of our OSHA topics and all of our workers' compensation topics. So now we're ready for kind of our summary. Worker safety needs to be a very high priority. It needs to be part of the culture of an organization that's ultimately going to be successful. And it certainly needs to be a priority in the HR department and also in the loss prevention department. Even though it is a less central role for HR than it's going to be in loss prevention or security or whatever your particular entity calls that function, HR definitely supports the culture and assists the loss prevention function in making that a real thing. Worker safety is a bottom line issue in terms of the profitability of the expense of the organization, but it is beyond a bottom line issue. It's also about employee morale, and it's about business ethics. It's about hiring the best and keeping the best. If you are in HR, you may well be asked to participate in making a decision about whether your employer goes bare or not. If you happen to be working in a different state, you may be involved in deciding what type of insurance product or what type of company you're going to use for your workers' compensation coverage. Usually there will be some financial people also involved in this, but oftentimes HR is involved to some extent. In addition, keep in mind that there are reporting requirements both on the workers' compensation level and the OSHA level, and there is definitely the need to have the various posters and other communications available to employees. I hope that this presentation has been helpful. Of course, you may have noticed we didn't do as deep a dive this time in these topics as we have in other presentations. So I certainly don't expect you to have a deeper knowledge than what we've covered today, but I wanted you to have at least an introduction to some of the big topics in this area. If you have questions, of course, please feel free to reach out to me. My email is cgroover@collin.edu. I would love to hear from you. Or better yet, stop by my office hours or call during my office hours. I'd be delighted to talk with you in more detail about these topics. I thank you for your attention, and I hope you have a wonderful day. Take care.